Hey, I'm Pat Iyer, and in this podcast, we're doing a longer session than usual. You'll have an opportunity to dive deep into a topic that encourages you to think about and avoid the mistakes associated with being a legal nurse consultant. Tim Kane interviews me along with his partner, Jennifer, to focus on what we need to do as a legal nurse consultant to build our businesses after we get started. In this interview, you'll have an opportunity to hear from all three of us as we talk about issues like presenting your credentials, about not defining who you serve, by not putting enough focus on the value you deliver versus your background, how to follow up, what cold calling means today and whether it still works. We cover a far-ranging number of topics that you'll want to be sure to watch on our YouTube channel at Legal Nurse Business or listen to wherever you get your audio programs. I look forward to hearing from you and your reactions to the show. You can email me at patiyer@legalnursebusiness.com and tell me what you thought of this session.
Well, hello, everyone, and thank you for joining us on March 10th. Hi, Jennifer. How are you?
I'm good, Tim. How are you?
I'm good, and I want to tell people that you and I run Medical Legal Connection. We are an organization of registered nurses and various other medical professionals that perform medical legal services of any kind for any law firm. And we have a special guest today. We'll get right to it. We even already have 2 to 3 people in our room. So before I even tell you who our guest is, everybody knows who it is. At any time during our conversation, please ask any questions. We will be happy to jump on them. So our special guest today is going to be Pat Iyer. Everyone knows who Pat Iyer is. She's a highly experienced legal nurse consultant and a business coach. She helps countless of LNCs, and I've seen her personally help countless LNCs build successful businesses. And today we're going to talk about something critical. The biggest mistakes, let me repeat that, the biggest mistakes new LNCs make and how to avoid them if you're just starting out. Hello there, Pat Iyer. How are you?
Hello, Pat.
So I basically already explained what our topic is, and welcome to LNC Talks.
Thank you. Thank you. I'm glad to be able to share some of the things that I've learned along the way, including some things that I've learned the hard way that I don't want your attendees to have to repeat.
And we appreciate that. So we're excited to hear what you have to say. And it doesn't matter how many times you hear it, it still sounds like the first time, and it just helps you think of what with the next case that comes along, of the ins and outs of something that could happen or mistakes that we make and we can correct. So
well, let's get right to our very first mistake. Like everyone's always said, the best thing is learn from our mistakes. So Pat, tell us about not defining who you serve and what you offer.
This is one of the issues for legal nurse consultants, particularly when they're new, trying to figure out what makes them special. What is their background that will help the attorneys they want to reach? Many of us got standardized language from our legal nurse consulting programs that say, this is what I do. I screen cases for merit, I identify the standards of care, I write a chronology, I find expert witnesses. Well, that's great if your target is medical malpractice attorneys, but they are a small subset of trial attorneys. There are a lot more personal injury cases. when I've exhibited and I've had attorneys come up and look at my booth and say, oh, you're a legal nurse consultant. I don't do medical malpractice. Then I say, well, what kind of law do you practice? Oh, like most of the guys here, I do personal injury. Do you ever encounter medical records that you don't understand or have complex details in them? Or you wonder, what are the complications that this person experienced? That's where I can come in. Oh, you do more than just medical malpractice. When you're marketing on your website or through your content, medical malpractice, medical malpractice, medical malpractice, then you are excluding a larger population. And that larger population needs your assistance. So yes, you can market to medical malpractice attorneys. If you've got a background in orthopedics or working in the emergency department or in critical care, you are perfectly positioned for personal injury cases. You know about neck injuries and back injuries and fractures and malunion and osteomyelitis and all the other complications that are worth a lot of money to the plaintiff in particular. So be clear, what is your background? Who do you want to reach? And is that a good match for the services that you offer? And don't assume that all trial attorneys handle medical malpractice cases. Many of them send it off to another law firm in town or in the state, and then they get a fee when the plaintiff attorney wins. And I'm talking about the plaintiff side, not the defense side. They may hear your marketing and think, okay, but I don't do it myself. So be very clear. Who's your ideal target market based on your background, and what kind of services do you want to offer to them?
Just to follow up to that, a few things through my experience that I've seen other areas that a lot of LNCs don't think of is criminal attorneys. It's basically, like you said, any case that has a medical record to it. How many guys get arrested? I shouldn't say guys. People get arrested for some assault or violation, or something that were whatever they did, they got arrested, and another person was sent to an emergency room. That will involve medical records at one point. I've even heard stories of LNCs helping criminal cases to show that there was an injury prior to this incident, and help an attorney that way. The other way that I've been approached, but it didn't turn out to anything, but I've had divorce attorneys reach out to me on LinkedIn and say, a nurse would be great for some of my our child. I don't speak divorce legal lingo, or I'm not an attorney, but for a legal nurse would be great for our child custody battles or something, because I think those oftentimes, the attorney told me, have medical related issues with the child or the parent, and it would just like a summation of what's going on.
I have a vivid memory, Tim, of having a subcontractor transcribe handwritten notes by a therapist who was working with a child. The parents were battling over which parent would get the child. And we had to transcribe what was pretty illegible handwriting.
Wow.
And I want to go back to your comment about criminal attorneys, because I used to call them criminal attorneys. And then I thought, maybe that's not the right term. They're attorneys who handle criminal cases.
Yeah.
And I have had a client who became a criminal attorney when he had a bar down on the Jersey Shore, and he wasn't paying the government taxes that were required to take out of the paychecks. He was keeping all that money. He and his partner, who were defense attorneys, actually ended up going to prison and becoming true criminal attorneys.
Better call Saul. That's all. Wow. Interesting.
Wow.
So yeah, divorce and criminal, and there's so many different types besides med mal. But every new LNC that you see out there says, they think med mal is everything.
So with what you're saying, Pat, it kind of leads us into a question about how people focus too much on credentials instead of value. Like you really, Tim and I talk about this all the time. Like, what value can we bring to these attorneys? And in kind of what you were talking about, talk more about that.
it's very important to be clear on who you're talking to. Are you talking to defense attorneys? Are you talking to plaintiff attorneys? That's the basic question to ask in the beginning. And while I'm talking about that, I'd like our viewers to put in the chat their reaction to two billboards that I saw this weekend as I'm driving up Central Florida. One of the billboards from a law firm said, Harvard educated, and it had the name of the attorney on the billboard and his picture. The other billboard said, we recovered $44 million for our clients in 2024. I'd like you to put in the chat, which one do you think would be more appealing to the person driving through Central Florida looking at those two billboards? So as we focus on our value as legal nurse consultants, we're thinking in terms of what are the needs of that attorney? The defense attorney has a very different set of motivations than the plaintiff attorney. They know that they have to settle some cases, and some cases really are the get out your checkbook variety. But they want to settle them for as little money as they can. They want to please the insurance carrier. The insurance carrier is part of their food chain. So if they have a series of losses or big verdicts in court, and they are concerned about minimizing how much they have to pay, they want the legal nurse consultant to help them with what are the things that the legal nurse consultant can do to minimize what they have to pay out. And then for the plaintiff attorney has very different motivations. I want referral sources. I want to do a good job for my clients. I want more clients. I'm in a crowded field. If you drive along the highway in certain parts of this country, you see one billboard after the other. The stretch from the Philadelphia airport to my home in New Jersey has about 7 different firms that are advertising, and not just one billboard. Some of them have 2 or 3 billboards. So I'm seeing some correct answers in the chat. The second one, the $44 million verdict, is going to be far more appealing to somebody driving along than we are the greatest. The Harvard-educated attorney, by the way, has a competitor who's got a billboard that says, I am Yale-educated.
Yeah.
Like the two of them are competing with each other, but for the person driving on that stretch of the road, well, it's fine you went to Harvard, but what are you going to do for me? That's what I'm concerned with. And it's the same concept when you're marketing to attorneys. What are you going to do for them to make their lives easier, to help them with litigating the cases, finding the information in the medical records that makes a difference, and will help them win their case, whether that's a win for the defense, which is the jury didn't assign any responsibility to my client and didn't award any damages, or for the plaintiff attorney, how can I get the maximum amount of money that I can for my client? Because I'm working on contingency fee. Unless I get a settlement or an award, I'm out all that money. And it can be hundreds of thousands of dollars, particularly for complex medical malpractice cases.
100%. I have a couple of comments to add to that. When I'm networking and when I talk to other LNCs, I just want to echo again, the word value is, and it kind of goes to, it ties into your billboard story as well, is when an attorney, why do I need an LNC? Well, I can bring a ton of value to your case, and that usually will get their eyebrows. Now back to your billboard case, the billboards were like, I'm in Harvard and I'm in Yale. It's kind of about them, and it's not telling the potential customer what value they can bring to them. Where you see the billboard with the money, it's like, well, that's where they would want to go towards, because it's all comes down to value in the end.
Mm-hmm.
Well, then carrying on further with value. So, Pat, you talked about when you talk with those attorneys, saying, do you understand the medical records? Do you understand the language? And for a new LNC, like they have that understanding of the medical records, but then it comes, what fee, what hourly rate do they assign themselves? And often, because they're inexperienced of being an LNC, their rates are lower. However, they really do have the knowledge base to go through those medical records and process what's in them to talk to their attorney about that. So what would you say would be what would you say to a new LNC when the attorney asks about the rates, the new LNC rates?
It shouldn't be the first time you think about the answer to that question when an attorney is asking you. You should be able to have it come out of your mouth in a very smooth way. You've thought about it. I know that we were highly sensitive as a profession, that I can't say to you, Jennifer, I think in Minnesota you ought to charge X, because we are constantly being reminded about price fixing. There are ranges in different parts of the country that we need to be aware of, and they're tied very clearly to the cost of living and also to the expectations about what the market will bear. The rate that Tim can charge in Manhattan may be very different than a rate that a nurse can charge in Kansas. That's the reality. Two similarly educated and experienced people. I had an attorney in Virginia one time who was giving me a hard time over the rate that I quoted him for working on his personal injury cases. He would send me a binder and he would say, I want you to critique this and tell me what's missing. What do you think is helpful about the settlement binder that I've sent you, which had chronologies and examples of medical equipment and his demand letter? It was all put together very nicely by somebody else, and he used me as a sounding board. And I told him my rate, and he said, oh my goodness, I've got nurses who would work for me for $50 an hour. And they do it at their kitchen table, and they love the work because they're not being splashed with blood. I thought, well, I said to him, I can't work for that rate. And he ended up sending me work at the rate that I quoted him. Those nurses were undervaluing themselves. I think there's more to life than not being splashed with blood. But that stuck in my brain forever, that in his mind, it was high-priced Pat, low-priced nurses, but who did he choose was me, not the person who was charging a very small amount. When you fill your calendar with low-income work, you don't have time to get the higher income work or to market for the higher income work or even to do the higher income work. We all have a finite number of hours per day that we can work. And if you still have a clinical job and you haven't quit your day job, which is another point to keep in mind, then you've got the demands of your clinical work and the demands of building a business. So don't underestimate what you can charge and don't cheapen yourself. Be able to say with confidence, your hourly rate, have a well laid out fee schedule and a fee agreement that will protect you so that if you end up with collection problems, you've got a backing, you've got a document that the attorney signed indicating that they understand this is your hourly rate. And these are the consequences if the attorney doesn't pay the invoice on time. So those are key points when you think about setting fees and enforcing your fees. It's not a negotiation. The attorney doesn't get to say, hey, Tim, I don't really feel like paying you that much, but I'll pay you X. No, the attorney doesn't set your rates, you do.
So the key word here is confidence. And I want to say something that happened to me in 2012, and I'm still paying for it today. I, just like all the other brand new LNCs, when it came down to fees, what's our biggest fear? If we go too high, they're not going to hire us. I made that mistake, and I still have clients today that started with me back in 2012, but I only could my rates were too low, and I can't really get them up to a great rate because once you're at a certain number, you just can't say, oh, you know what? I realized my rates were wrong. I'm going to go up 75%. That's going to cause a shock. So that's a mistake that I've been living with and I've learned from. And with other clients, I've straightened it out with new ones. But don't make that mistake of, I don't want to charge too high. I'm afraid I might not get the work. if that's the case, just someone else will be, coming down the road, like, another attorney for you.
Yeah, that's a challenge, Tim. And it's a very common mistake. I'm hungry, I'll put a lower rate, that'll be appealing to the attorney. But you're advertising that you are inexperienced when you state a lowest rate. I call it the race to the bottom. If you're charging X, then your competitor will undercut you and charge a little bit less than you, and then you undercut them, and you end up hurting yourself. It costs a lot of money to be in business when you're paying your own benefits, your own insurance, you've invested in marketing and in equipment, you've got a lot of administrative time. You have to be able to charge enough to be able to cover your costs to make this a reasonable decision for you. And particularly as staff nurse rates increase in hospitals, you're thinking about, well, what would I earn if I put on my scrubs and went to work versus what do I earn if I'm sitting at my desk working on cases for attorneys?
Mm-hmm.
Pros and cons for both roles. Both of them have their own rewards, but you don't want to end up charging less than your hospital employer would give you for going in to do a shift. That is a minimum groundwork is for you to consider. And your employer is paying your income taxes and likely giving you some benefits like paid sick time and vacation, which are nice things that I remember way back when I had a steady paycheck and I got those things. But, now there's no sick time for me that's paid and there's no vacation time that's paid. I have to think in terms of being a business person and what I need to charge to cover those expenses.
I was talking with a business person one time just about business related things. And we were talking about prices. Long story short, he said, think of it this way. When you go to Amazon and buy a TV, Amazon.com, are you going to buy the cheapest? I go, of course not. I'm not going to do that. The lowest cost. And he said, why? Because I'm afraid that quality won't be as good as the others.
Mm-hmm.
So I think LNCs should kind of remember that point as well, is I have quality here. If my rate's extremely low, then I'm showing you that I'm not that, high quality.
And we have a couple of questions in the chat, Tim, about finding out typical rates in your area. It's a little tricky. If you call up one of your competitors and say, as somebody called me up one time and pretended to be from a law firm, oh, I'd like to know what you charge. I'd like a copy of your fee schedule. And it was something like, Cecilia Parks at yahoo.com. People who work in law firms don't use yahoo.com or Gmail as their email address. That it would be russellsmithlaw.com. It just smelled like a trap to me, and I didn't answer. Get to know some of the LNCs in your area. You'll find them at networking events. There has to be a level of trust before people will talk about their rates. You can do some research on the internet for your area and see if you can determine that. It requires some digging. If a person perceives you as a competitor, a direct competitor, they may not answer that question for you. If you're part of Tim's Facebook group, and if there is discussion about rates, and Tim, I'm not sure if that's part of the culture of the group, you can get general senses from people about what they typically charge. But it's highly dependent on your education. It's highly dependent upon the service that you offer, and it's highly dependent upon where you live. You got those three factors. So somebody's number in one part of the country may not match your background or what you're doing. Expert witnesses charge higher levels than behind-the-scenes consultants. Some people charge flat fees for working on a case. Some people charge hourly fees. All of that is for you to sort through and then experiment and see if people are reacting. I had a psychiatric nurse tell me when I first started business, she said, Pat, you're charging enough if 75% of the people you talk to don't go into an immediate cardiac arrest when they hear your rate. Then you're in the right ballpark. But
And
that
the
other
other thing,
5% that just pretend like, oh my God, a nurse is charging that much. They're not your target audience anyway.
Mm-hmm.
I agree with that. I've often felt like, because I have said my rate and there was really no reaction, or it's like, that's fine. What the inkling I get is, I probably could have been higher, and I think he probably would have been fine with it. And the other thing I want to say too is, I have some attorney clients I've had for years never asked me my rate once. Never. Just I send an invoice, they pay it.
Isn't that a wonderful thing?
It is. So in talking about this, what new LNCs don't really know how to talk to attorneys. What kind of tips would you give them, Pat?
The attorneys have all different personalities, from the very personable, outgoing ones to they come into the deposition with all their questions on a yellow pad and they put a check mark next to each question. They're conscientious, they're driven, they're OCD. The key is, of course, to remember, going back to what I said before, are you talking to a defense attorney? Do you understand what motivates them in terms of pleasing the carrier and minimizing their exposure? Are you talking to a plaintiff attorney whose ultimate goal is to maximize recovery and cover the expenses of the law firm? And listen as you're speaking to them. What are the things that they're telling you are important to them in making a decision about hiring a legal nurse consultant? I believe if you can speak to demanding physicians, you can speak to demanding attorneys. If you think about somebody sending a cue to you, just give me the information quickly. Think about calling up a physician and saying there's a change in your patient's condition. Do they want to know 7 paragraphs of information before you tell them that the vital signs have significantly changed? Or do they want you to get right to the point? Attorneys are busy. Many of them want to know quickly, what can you do for me? What will you charge me? Do you have the capability of working on this case for me? Do you have the time to do it? What would be your expected turnaround? Those are the kinds of questions that you'll get, not only from your existing clients, but from new attorneys who are considering giving you a chance. They want you to answer those questions smoothly, professionally. And if you hear something that you don't understand, it's okay to say, that's not a term that I'm familiar with.
Mm-hmm.
Like my first case, a girl fell in a bathroom, cut her knee on her glass IV bottle. That tells you how long ago that case was, when I was an expert witness in 1987. And after I wrote my report and the attorney turned it into the plaintiff attorney took out his checkbook and he wrote a check to this girl and said, here's some money, go away. Now that case was dismissed with prejudice. I had no idea what the term dismissed with prejudice meant. He was laughing when I asked my client, like, does this happen very often? He said, no, Pat, but it means because she took money, she can't go to another attorney and say, I cut my knee on the IV bottle, I want to sue the nurses. He was very happy to explain that to me. That was my first case, and I encountered legal language that was mysterious to me. It's okay for you to ask attorneys who are requesting your services to explain something that's not clear to you. They learned all these things themselves. They appreciate being in the role of teacher. And yes, you do reveal your inexperience when you say, I don't know what that means. But it's better than to try to pretend that you do, and then you end up getting in trouble because you don't understand the implications of what the attorney said.
And on the flip side with that, Pat, I find attorneys are eager to learn the medical part of their cases, just like like medical terminology, or what does this mean? And clearly with their cases, like causation, like did this cause this, or incidental findings and stuff that we just talk casually as a nurse. So on the flip side, attorneys too like to be educated about what's in the medical records, and they ask questions. So that's kind of like the pairing, though. We understand the medical records. they understand the law. So we're learning from them the law, and they're learning from us the medical part of it. And then that's how we blend together.
And that's why the name of our
case.
business is Medical Legal Connection.
Mm-hmm. Exactly.
Connecting
right to the point there, Tim. Yes. I love it.
I'd like you to imagine this situation. You're booking cases regularly. Attorneys respect you. They pay your full fee without question. You've become the go-to LNC in your area, and you're making more than you did at the bedside with fewer hours and on your own terms. There's no more guessing. There's no more wondering if you're doing it right. There's no more comparing yourself to other LNCs who seem to be ahead of you. You have a clear path, and you have the support to follow it. I'm introducing to you now my new course, How to Start and Build Your LNC Business. But you may be thinking, I've already spent money on becoming an LNC. Can I afford another course? Here's a better question. Can you afford to keep spinning your wheels? This isn't just another course. This is the roadmap that you've been missing, the one that shows you how to turn your skills into a real business. The course is for you if you're a nurse with clinical experience and you want to build a successful legal nurse consulting business. You're tired of trial and error, and you want a proven process. You want more freedom, more income, and more impact from your work. And you're committed to making your LNC business work, and you just need the right guidance. You don't have to figure this out alone. With the right strategies and tools and support, you can build the business you imagined when you first became an LNC. Enroll today to take advantage of this opportunity to complete the 5-part course. You'll get real-world guidance from me. I built a multi-million-dollar LNC business. You'll get tools and you'll get templates and you'll get scripts that you can use immediately, and you'll get assignments to complete, which I will personally review with you and give you feedback on. Enrollment is open now. The clients are out there. The cases are waiting for you. All you need is the system to connect the dots. Let's work together to build the business that you deserve. This course is taking place live April 8, 15, 22, 29, and May 6, 2025 at 8 p.m. Eastern. It will also be available on demand when the live course is over. So take advantage of this opportunity to get this business-changing content and skills and support that you need to move your business forward. How to Start and Build Your LNC Business course is waiting for you.
So
I see a question. I'll even post. I can post it up. I can show everybody.
Sure.
Yeah, let's do that. There.
Yeah, Adrian, that's a great question in terms of follow-up. I was just at the National Speakers Association Winter Conference in Orlando this past weekend, and somebody brought up the point of how many touches do you need? How many follow-up attempts do you need? First of all, we'll talk about what kind of follow-up, but then how often should you be following up in order to be able to get the attention of the attorney? It used to be we would say 5 efforts to reach an attorney. Now it's up to 11 or more. Sending out material that an attorney hasn't requested is a cold method of marketing. And the methods of cold marketing don't yield as good results as a warm lead or a referral. What makes a warm lead is when you know something about the attorney. You can put in the cover letter, I saw you were trained in Harvard, and I went to school in Boston. I'll bet we know some of the same people in the town. Or how about those Boston Red Sox, or whatever is the appropriate analogy? And I'm not a sports person, but I think that there are Boston Red Sox. You're working on trying to find something in common with that attorney when you approach the attorney, rather than it being a cold approach. Attorneys get bombarded with emails from legal nurse consultants, phone calls from people who are trying to get past the gatekeeper, material that comes in the mail. It is a numbers game. It can work, but you have to go through a lot of rejection when you try cold calling, cold phone calls, cold mailing. And you may spend a fair amount of money on postage, on flyers, on brochures in order to do so. It is better, if you can work it, to use your network of people. Your next door neighbor who was in a car crash had a plaintiff attorney representing that person if they were hit, or a defense attorney if they were the ones who did the hit. Who do you know in your circle who knows attorneys? Who's in your church, your synagogue, your temple? Who's in your neighborhood? Who's in civic groups? Who in your family knows attorneys or have used attorneys? Uncle Bob has a divorce attorney. Uncle Bob's divorce attorney went to school with Susan, who is a personal injury attorney, and set up a practice in town. So it's looking at your networks and getting to the people who then will say, oh, yeah, Jennifer, I understand that you're starting your business and you're looking to connect with personal injury attorneys. I'd be happy to introduce you to an attorney who has those kinds of cases. You're asking for the introduction. Absolutely. You're not going there cold, which is a numbers game, as I said. Eventually, you'll find somebody who needs you. They have a case. They remember you, but you have to go through a lot of people in order to hit that. And many LNCs give up long before they have gone up to the numbers of people that they need to reach before somebody says yes.
The big key here is, I like to say, is no matter how frustrated you get, don't give up. And because it's so easy to give up. Another thing I like to say to LNC sometimes is everyone has a relative or a friend who's an attorney in general. They don't have to be a personal injury attorney. They don't have to be med mal. But if you can even get any attorney that you could just talk to and say, hey, this is what I'm trying to do. What do you think? What do you think would be my best way? Or do you know anybody? I mean, that's, I know 2 attorneys related to my family that are unrelated to personal injury that I could call at any time. And I just think that's another avenue to consider.
And one of my colleagues went to a law firm, and again, it was many years ago. She started her business this way. She went to a law firm and said to the attorney, now, what do you think would help me get started as a legal nurse consultant? He thought she was a client in the waiting room. They made a mistake. They didn't screen her properly. They allowed her to go back and talk to the attorney. And after he recovered from his surprise that she wasn't there for her own case, he took some time and talked to her. And in the process of talking to her, he talked himself into using her, and she left with 4 cases.
Wow.
Now, it's harder to do that today. It's harder to walk into law firms. And because of COVID changes, many attorneys are still working at home. And they've got staff who are really carefully screening who you are and what do you want. So the cold visit doesn't work as well as it used to. But the fact that she started that conversation with the attorney, who really had no idea what a legal nurse consultant was, that conversation could have been at a networking event for Chamber of Commerce or Bar Association. There's a lot more awareness now than there was 30 years ago about the value of nurses helping attorneys. And there are attorneys who've never used a legal nurse consultant and are open to the idea. So you don't know who is going to be interested unless you start working your networks and finding out who knows an attorney who handles cases with medical issues.
And to that effect, Pat, I think, and even to you, Tim, I think you said it very well. Like it doesn't take 5 times to get to that attorney. It takes 11 times. And it does. It really takes consistent follow-up until they have it in their brain, or somehow they're on a case and they're like, they kind of remember this call and it was you like the 20th time. Then they'll pick up the phone and it's like, and they'll talk to you about that case. So that's very significant.
Repetition.
Repetition. Yeah.
Yeah. And it's hard because we as nurses are used to people instantly respecting us and liking us because of what we do. Mm-hmm. We have this little button, which is, I envision it as next to my sternum, that says, "Oh, I'm a nurse, I can help you." And you'll like me because I know how to talk to people. Well, that is all true. But just because we want to work with the attorney and we want to be liked, it doesn't automatically mean that the attorney has the need, has the money to pay us, sees us as the solution, and are nice people to work with. That's my definition of the ideal client. They have the need, they see you as the solution, they have the money to pay you, and they are nice people. Those are the ones that you want to look for. All factors have to be in place for that to be an ideal client for you. You can't just deal with, they've got the need and they see you as a solution, but oh, guess what? We don't have the money, or we expect you to wait until we settle the case before we're going to pay you. No, we don't do it that way. Or they might not be nice people. They've got all those other 3 qualities, but they are angry and aggressive people, and they come across on that initial call as being aggressive with you. You don't have to work with them.
That is so true.
I see one more question we could do. I'm going to put it up.
Yes. Adrian had asked, and then Ms. Edwards followed up, or Mr. Edwards followed up with asking to speak directly to the attorney. You can certainly first try the attorney. If the attorney is not available, ask for if you could be put into voicemail. If the attorney's not available and they don't have voicemail, you could ask to speak to the paralegal who works with the attorney. They might have more than one, which then gets you into the tricky question of, oh, what case are you calling about? And you're not calling about a case, you're calling about your services. This is why it's hard to reach the attorney. They're busy, they're working on cases, they've got people screening their phone calls. Yes, you can try. Yes, you can leave a message that stresses the benefits of working with you. Not, I do this, I do that, I do this, I do that, but I can assist you with your medical cases and understanding the injuries that the plaintiff sustained. As an example, I'd love to set up a time to talk with you. Always see if you are able to reach the attorney, that you can get a specific appointment, a date and a time for a phone call with the attorney, and get that locked down so that it's not, well, I'll call you in a week or 2, or I'll call you when I have the need, or I'll call you when I'm available. Give it your best shot to get a specific time and an appointment date to speak to an attorney about your services. Knowing, as I said before, you're going to deal with a lot of rejection in this process, a lot of phone calls that are unanswered. You will think that you're invisible, or you think that your phone is dead. It's part of the cold calling process that you will not get responses back from anyone other than a small percentage of people. And don't take it personally. Don't be crushed. If that's the way that you want to market, then you have to deal with rejection.
100%.
And have a little thick skin.
Yes.
Yes.
Do we have any other questions?
Do we have any other on the list of our mistakes there, Jen, we want to hit? Or Pat? We've been at this 40 minutes. I mean, that's okay. But I know sometimes the audience can get a little,
Sure. Well, we haven't talked yet about having a clear fee agreement, which is one of the mistakes I see legal nurse consultants who have tables that show the rates. I will do this work for this dollars per hour, for example. A fee agreement is a more expanded version of a table. It defines who supplies the medical records, in what form. It indicates when you expect to be paid. It may state an interest rate if the payment is delayed. It will state if you're an expert witness, if there's a cancellation fee, and what time frame in which a cancellation fee is due. It will cover who pays for your deposition, when you expect to be paid for your trial, all of those nuances that go into providing your services. And one of the things that is also important is to make sure that you're asking for a retainer. Mm-hmm. You're getting a replenishing retainer when that first retainer is almost used up. And that if the attorney has a dispute about your invoice, they have to put it in writing within X number of days after receiving the invoice. Otherwise, that's a final invoice, and you're not going to be put in a position 4 months from now negotiating with an attorney who doesn't want to pay that invoice. They have to object right in the beginning.
And so with saying all that, Pat, it's like as I'm listening to you, it took me a while to get comfortable with that. And I think like nurses, we care about people. And I think we tend to go soft when it comes to negotiating our fee and our value. And how did you work with that when you were starting out? Did you face those challenges? And when did you feel comfortable with that?
That button that says, I'm a nurse, I can help you, is the one that we're talking about when it comes to negotiating your fees. We have a tendency to give people the benefit of the doubt, which is an honorable thing to do. And when we are new, we don't always see the warning flags. Mm-hmm. When the attorney says to me, or somebody called me from California and said that they're working for an insurance company and they wanted me to summarize medical records of people who are applying for life insurance. And he said to me, and these are his exact numbers, I've heard quotes for $60 an hour. Can you do better than that? And I thought, well, better for him or better for me? What are we talking about here? And I said, no, I can't review those cases for $60 an hour. And at that time, I was charging $160 an hour. So I said, no, I just can't do that. And we pleasantly said goodbye. That was a red flag. That was a tire kicker, economic buyer who was valuing me based on a number that he wanted me to compete against or even underprice that number, quote a lower number than I had heard from him. And I wasn't going to play that game. You do, if you're paying attention, learn from your experiences, from reactions of attorneys, from times that you invoice and you have trouble collecting. All of those lessons are valuable. An attorney hired me by the name of John to testify in a case of an elderly woman who fell in the hospital. I had a deposition in that case. I had outstanding invoices before the deposition. I went into the deposition without those older invoices being paid. That was my first mistake. Then there was a trial about a month later, and I went into the trial without the older invoices being paid or the deposition being paid or getting a trial fee. That was my second mistake. He lost the trial. And he said to me, my client says I didn't do a good job in the case, and therefore I'm not going to pay you. And I said, oh, no, we're not going to do that. And I contacted an attorney who wrote a strong letter. And my agreement with the attorney was that he would get 25% of what he could recover. I was owed $1,200. The number is branded in my brain. And after my client got the letter, he wrote a check to the attorney. The attorney sent me a check for $900. He said, Pat, you lost $300 in this case, but it's going to be the best $300 that you lost. because you will never do this again. You will learn from this. So we call that the John rule. I'm not going to give his last name to protect his evil personality. But we built that into our fee agreement. We will not go to court. We will not have a deposition. And none of the 200 expert witnesses that I had under contract for me at the time I sold the company, none of them would be allowed to go for a deposition or trial before all outstanding invoices were paid. And they paid an invoice for the estimated amount of time for the deposition or trial. So no one would appear unless we were fully paid. And some of our clients didn't like that. And we explained the rationale. And for very good clients, I want to emphasize this, for very good clients who gave us a lot of work per year, we were flexible on that point, but only because we knew we weren't going to fight with them. But for everybody else, they had to pay first. Otherwise, the expert didn't appear. $300 taught me that lesson. I saved hundreds of thousands of dollars and a lot of aggravation by insisting on that in my fee agreement.
Good for you.
It's all in relationship. Like you said, like the frequent ones, it wasn't such a big deal because you had that relationship established. In the beginning, that it takes a little bit of time to get that relationship established with an attorney to get comfortable like that. And that's exactly the way to proceed, just like you said.
Checks are fine. Most law firms, Ms. RN Observer Services, who asked the question, most law firms hire a bookkeeper to come in and write checks. You can also accept credit card payments. It does come with a cost to you because you get anywhere between 2.5% to 4% removed from the credit card payment. Plus there's a monthly fee, plus there's a transaction fee. If you accept payment by Zelle, and I'm not familiar with Venmo, but I do use Zelle. Zelle does not cost anyone any money. You receive the full amount. You can also get a wire transfer from a bank, but there is a transaction fee, $20 or $30 that the person sending the wire transfer has to pay. And your bank might charge a fee for you receiving the wire transfer. But as far as I can tell, Zelle is the one, and checks, where you get the full amount. Be flexible in accepting money, but insist upon getting money as your retainer and that your invoices get paid promptly.
I prefer checks just for that reason, because those fees after a while, at the end of the year, you'd be surprised how much they add up to.
Oh, yeah.
Yes.
How about we can go here? Is it effective to offer a virtual education series to the office? You could do a virtual. My opinion on that is, even versus cold calling, I prefer the drop-in better. I mean, if you can, drop into a firm, even if it's cold. And then if you establish a relationship with that firm, ask to provide some sort of education. Get in that lunchroom, and you could really make some progress.
The lunch and learn can be very effective. It's probably most effective when you start working with a client in that law firm, and then the client says to their colleagues, hey, Jessica is coming in to do a program on medical records for our law firm. What are some of the questions that you would like her to address? And then Jessica is primed with knowing what are the needs of the attorneys who are going to be in the lunchroom. They have an expectation you're going to bring in food. You need some guidance from your client about what kind of food should you bring in. One of the people I coach went in fully prepared to give cookies for lunch, and then her client said, forget the lunch and learn. I've got a case. Come into my office right now. I need your help. She never got a chance to distribute the food. That's not typical, however. Typically, the attorneys are there in a conference room, waiting to hear what you have to say, and your job is to feed them, tell them stories, entertain them, give them tips, and make sure that every one of them has your contact information before you walk out of the room. So by virtue of this, lunch and learns typically are a local strategy that work if you're in a city where you've got some clients and they bring you in with the goal of introducing you to their co-workers.
True.
How about failing to follow up, Pat? What's your thoughts on that mistake?
We've talked about the number of touches that it takes to get the attention of the attorney. If you try a few times and you don't get a response, it's very easy to say, oh, let's cross that one off the list. The follow-up, however, is not, hey, would you hire me? Hey, do you remember me? Would you hire me? Hey, could you hire me? Hey, do you have a case where you could hire me?
Yeah.
It's reminding them that you exist, sending them helpful information. I know that you do personal injury cases, and I don't know if you saw this story that was about this local case involving a tractor trailer that ran over a convertible, gruesome thought, and the driver was killed, and the family got $17 million for the truck driver's failure to stop driving when they timed out, which is a concept everyone should know. You can't keep driving until indefinitely. Your employer says, that's it, X number of hours on the road and you're done. You need to pull over into a truck stop and stop driving. But there are drivers who push the limits, and then they get tired, and then they make mistakes. Here's an interesting case that you might be involved with, or you might be interested in. You might not have heard about it. In this kind of case, what I could do is to summarize the medical records of the driver, find out if they were on medications that affected their alertness, look at the company logs, and provide them with some concrete examples, what I could do in this type of case. If you got a case like that, keep me in mind. That's the kind of follow-up that's much more meaningful than the drumming over and over again. Here I am, I'm ready to help you. Here I am, I'm ready to help you.
Jen and I, when we market, we like to talk about hammers and nails.
Yeah, that's your term.
The example of that is the boring hardware stores. We have hammers, nails, screws, screwdrivers, and it's like just off to sleep. The LNC comparison is that I worked med surge, I worked ICU, I was the nurse manager. That's all lovely, but back to what we've already said a bunch of times this hour. What's the value that all that experience is going to bring to me? And I'm going to follow that up with our next item we want to talk about is sending a resume or a CV.
And it's interesting, just before you chat, Pat, I think nurses too have a hard time talking about themselves. And I think when attorneys meet with these legal nurse consultants and they look at their CV or their resume, it's like you have all that experience, but you don't talk about it. So can you speak further on that as you answer the question?
Sure. Well, first of all, most attorneys who do medical malpractice work, they're familiar with looking at expert witness resumes. And we go back to, do you want to be an expert? Do you want to be behind the scenes? An expert witness does not list cases or clients they've worked for, because that's a violation of the privacy. And they don't list that they went through expert witness training by X company. They're selling their clinical expertise that enables them to be able to competently answer questions on standard of care or on damages if they're a physician expert. If you're behind the scenes, it's ideal to show how your clinical background has prepared you to educate attorneys, to prepare reports, to work as part of a team. Like if you have management experience and you've got opportunities in your clinical role to run a staff meeting or to work on committees, you're working with teams of people. Law firms have teams of people. They work on cases. They talk about cases. I had an opportunity for 3.5 years to work from almost the beginning to the end of an OB case, and I was part of team discussions as a behind-the-scenes consultant where we talked about strategy for deposition. We talked about what we accomplished in that deposition. We talked about writing briefs, and I helped to write some briefs for judges when the attorney was challenging certain aspects of the case. I did research and taught the staff about the defense is saying this happened, but we're saying this happened, and how do we rebut this theory that we believe is incorrect? All of those things that you as a legal nurse consultant know how to do because of your clinical background, make sure that when you put your resume together or you review your resume at least twice a year, which you should be doing, that you're stressing your clinical background and how that helps the attorney. Otherwise, it becomes job descriptions that the attorney doesn't really understand, like, what did this person do and how is that going to help me? Always the focus is on what are you going to do to help the attorney?
Exactly.
Excellent advice. On to our next list. You may have covered this, but spending too much time on non-essential tasks. I have seen LNCs with, I don't even think they've marketed, and they want to, I'll let you discuss this, Pat. They want to get their website up, and they ask me if that's, an essential to get going right away.
I do agree that having a website is important because attorneys are going to want to check you out before they contact you. But a non-essential task might be something like what I did in the beginning. I decided I needed a sample case. What I needed was a sample report. But I discovered that in the process of developing a sample case, I picked failure to diagnose appendicitis. I did a chronology. I did a medical summary. I surveyed the literature. I wrote how it was diagnosed. I defined questions for a deposition. I figured out what the standards of care were. It was an excuse to prevent me from having to spend the time marketing while I was spending 2 weeks working on my sample case. I did send it out to an attorney who never reacted to it. Months later, I asked him, did you ever take a look at that? He said, oh yeah, I thought it was very helpful. But it was a procrastination tool. What I should have done was have a chronology, a good solid sample report that I could turn over to an attorney when the attorney said, do you have an example of what you've done? Yes, I have this chronology. I didn't need to put in all of the other pieces that just gave me an excuse to not do the thing that was scaring me at the time, which was connecting with attorneys.
Interesting.
It is so interesting. And look where you are now, Pat, from where you started to where you are now. And
it's one step at a time, Jennifer, just one step at a time.
It's
and
a marathon.
It's one step at a time.
It's a marathon, not a sprint. Some people think it is a sprint. And that leads into another, I think the last on our mistake list here is not investing in business and marketing skills. I often say business and marketing skills is the hardest part of this whole business.
It is, and it's nothing that you learned in nursing school.
Right.
Nobody taught you how to use an Excel spreadsheet or to identify your ideal client. Your ideal client was in the bed when you came in to work that day. You didn't have a choice. Whereas the components of marketing, of networking, of setting fees, of enforcing your fees, of learning legal language, all of that is part of your continuing education. You learn in an LNC program, and I strongly recommend going through some type of a program. Mm-hmm. There are many choices out there. You need to understand the foundation of what legal nurse consulting does, and then you need the business knowledge. And that's, you've been seeing this link running down at the bottom of the screen. That's where Tim and I have talked, and we've collaborated and had some discussion about what would be most effective in helping with the business knowledge. I have put together a 5-week course that goes through the basics, that helps you determine what you need to do to effectively start and then to build your business. And I encourage you to go to that link to find out more about the course, which is starting on April 8th.
April 8th. That's a great week because it's a little bit before Easter, and then that's a good time to it's a virtual course, so and it's much easier than traveling and hotels, and a lot of knowledge and experience can be gained by signing up.
But
Absolutely.
just with talking with Pat today, aren't you just eager to learn more? It's like there's so much involved in being a legal nurse consultant, and it's so exciting. And having the wisdom of Pat and having her share those tips, fantastic.
Been wonderful. Yes, eventually, you can, it takes a while, but you can leave the bedside. But the more knowledge that you get and the more your business develops, that can lead you to that goal. But it's not a sprint, it's a marathon.
Yeah,
Well,
that's a great point, Tim.
Yes.
You have to walk before you run.
So, well, we've been at this for an hour, going on an hour and 1 minute here. Here I have I just want to put this up. This is one of my old DME students. That I'm glad to see he's doing well, and he's got himself a good title, RN Observer Services. Robert Chiofalo, RN. I do remember him very well from a couple years ago. I just wanted to give a little shout out. And LNC.tips, the LNC.tips/Tim Start, and you can sign up for this course, and you will not be disappointed.
Not at all.
Thank you, Tim.
All right. Well, I think that's going to be the end of it. And this has been a wonderful hour. The audience participation's been spectacular. And the people can see this replay. And if anybody wants to contact myself personally, my email is here. There. That was Tim Kane at medicallegalconnection.com. Feel free. All right, so we're gonna head out and enjoy the rest of the afternoon, and good luck on this Marketing Monday, everyone, and enjoy the day. Bye.
Thank you for your time, Pat.
You're welcome. I'm happy to be able to share. This is an exciting field, and it certainly has changed my life and given me opportunities to use my skills in a very effective and very profitable way. I encourage people to stick with it, be persistent, be consistent, focus on your marketing, show attorneys your value and how you're going to help them, and then they in turn will turn to you.
Wonderful.
Perfect.
Thanks again, Pat.
Great note to end on. Bye-bye.